Welcome to Financial Planning Explained. I'm your host, Mike Menninger, certified financial planner, owner and founder of Menninger Associates Financial Planning. I'm joined today with Nick DeVito, also a certified financial planner, who is one of my associates. Nick and I do a lot of presentations to the public on fundamentals of estate planning. What we would like to talk to you about today, this is going to be a two-part episode. The first part is going to be talking a little bit more about the fundamentals of estate planning. And in our second episode, we're going to be talking about is maybe more advanced concepts of estate planning, as well as the taxation of estates. So let us begin. So what we're going to do today is, we've been taking this on the roadshow for probably 5, 6, 7 years.
Yeah.
We teach this as adult education to a variety of different communities. It's a way of giving back to the community and an education side. It happens to also be what we teach at Temple. But you know what? When you're teaching to a bunch of 20-year-olds about estate planning, it's a whole lot different than when you have an audience full of 60 and 70-year-olds who are really, really thinking about it.
Yeah, it means a little bit more to them.
Correct. Generally speaking, for what it's worth, we're going to get the same amount of questions with this camera as we do with the classroom.
Yeah.
But we get a lot of questions from the folks who are experiencing it because guess what? You know what the big difference between the college student and the adult, aside from their age, is the college student has to be there. The adult wants to be there.
That is very true. The college student is there because they have to be and they're trying to pass an exam.
That is
the adult
correct.
wants to be there so they can plan for themselves and as it directly pertains to that.
That is correct. And this is the one that I really enjoy because you can touch on a lot of different things. We try to use examples to spur the audience to make them think, and I just have fun with it. But I definitely do better with an audience because when they're asking questions, it allows us to go. So we'll do the best we can with a dead audience here called the camera. So anyway, the 6 areas of financial planning. You've got cash management, tax planning, risk management, which is insurance planning, investment planning, retirement planning, and estate planning. They're all integrated. Kind of makes sense. Cash management starts with today. Estate planning is what happens upon my death.
Mm-hmm.
The one area that probably is most impactful is tax planning because there's a lot of things that you do during your lifetime that is preparing for the estate planning to maximize tax efficiency.
Yep.
So we'll be touching upon that.
Yep, absolutely. And kind of getting into it, I know we joked about it in the beginning that estate planning is only for the uber wealthy, and that could be further from the truth. It couldn't be further from the truth, I should say, because there are 5 basic elements of every estate plan, 4 of which pretty much pertain and apply to every individual, regardless of how old you are, how many assets you have, and whatnot. And I would say the first and the one that people are most familiar with is going to be the will. Everyone's heard about the will. The will is going to dictate where assets go, who takes care of young children, who the executor of that will is. The executor is the person that actually facilitates and makes sure that whatever the will says actually happens. Who takes care of young children? Is there trusts that are created from the will? So I would say the will is the document that people are most familiar with, and people oftentimes think that it's kind of the end-all be-all, that the will is the only document you may need, and that it dictates what happens to everything. We'll touch a little bit more on what exactly the will actually dictates a little bit more later. The second element of an estate plan is going to be your power of attorney, your durable power of attorney. The durable power of attorney allows someone else to act on your behalf should you become incapacitated. And when I say act on your behalf, financial transactions, calling the bank, paying bills, any decision that you would be making for yourself, the durable power of attorney allows someone else to make that for you. I don't know if any of you, I know you have experienced it. If anyone out there has experienced trying to call a financial institution on someone else's behalf, even if it's their husband or wife, they're not going to tell you anything.
Not allowed.
Not allowed, not by law, without that power of attorney.
We'll finish with that. Let me finish and add one more thing as it pertains to the durable power of attorney. Normally, if it's a husband and wife, they have the durable power of attorney for each other. One thing I can tell you is that there's another form of power of attorney, is what's referred to as a springing power of attorney. A lot of people feel really squeamish about having someone other than their spouse be the power of attorney. For example, if I'm widowed or divorced, I'm single, whatever the case may be, the concept of my handing over a power of attorney to someone else who legally could pick up the phone and withdraw all my assets makes me feel a little bit squeamish. So they have what's also called a springing power of attorney. Springing power of attorney is it only takes into effect if the individual is incapacitated, at which point they would need to have it basically signed off by a doctor that they're incapacitated, which springs into action that the other person becomes the power of attorney. I'm not here to recommend one or the other because, interestingly enough, I've interviewed multiple estate attorneys on this particular topic. I've had some who love it, some that hate it, and some are neutral on it. So I just want to bring that out to your attention simply because it exists. And for those people who are really, really uncomfortable about handing the keys over to somebody else, I could certainly understand that.
Yeah, absolutely. Just out of curiosity, when you said some of the attorneys like it and some don't, why do some like it? Why do some not? I would assume that the ones that don't are potentially because it adds a step that has to be taken care of and it's not as instantaneous. Is that one of the major drawbacks?
That was one of the major drawbacks. Okay. And because that could be hard. Then, some doctors don't like to do that because now it puts the doctor under a tremendous potential liability.
Yeah.
Because now all of a sudden the doctor signs off, okay, said individual is incapacitated. Now that doctor is opening the door, basically taking and handing the keys from that individual to whoever that springing power of attorney is.
Yep. Okay.
So, and it could vary from one state to another. And the thing that we should also point out when it comes to estate planning, what we're talking about here is, albeit specific, it's very general simply because of the fact that it can vary. Actually, it does vary from state to state. And as it pertains to the executor of the will, if I die, someone takes my will and goes down to my county courthouse for the sake of executing the will. The problem is that every county in the state oftentimes has slightly different procedures. Mm-hmm. Each state is different when it comes to estate tax and estate administration, some being easier than others. My understanding is Pennsylvania is on the easier side. There are other states that are not on the easier side, which we'll talk about when we get to trusts. So pick it up from the...
Yeah. And to Mike's point, we're going to be talking about both some state-specific stuff with Pennsylvania, but also the federal side, because there are federal estate tax or federal estate planning considerations, and there's also state and local estate planning considerations. So we'll let you know when we're jumping back and forth. Kind of jumping back into the elements of the estate plan, we talked about the durable power of attorney. You also have the medical power of attorney, which is very similar to the durable power of attorney, but for medical decisions. So in what we were talking about earlier, whether if someone is your medical power of attorney, they are now able to make medical decisions on your behalf. They are now able to inquire about doctor's records and all that fun stuff. Many think that if you are married to someone and your husband or wife is in the hospital, that you're going to be the one that's making those medical decisions. Not necessarily the case. A lot of times they will defer to you, but they do not legally have to without that document in place. So that's an important consideration. Another thing we always recommend when we do these presentations, we were talking about doing it in the college versus to the adults. One thing we always say to the adults, and even in the college classes too, is one of the best gifts you could potentially get your 18-year-old child for their birthday is a medical power of attorney. Because even as a parent, once your child turns 18, you no longer are legally the hospitals no longer legally have to provide the medical information to you. They don't have to let you make the medical decisions on their behalf. Like I said, they will sometimes, but they don't technically have to.
In fact, they could be in trouble if they release the information because they're legally not allowed. And so there are some universities, and I don't know what your experience was, but I know there are some universities that when you go to college, they basically will make you sign off a medical power of attorney, allowing the school to make the decisions if they have to on your behalf. But to your point, it's always a good thing to have the medical power of attorney. And my wife's going through it, okay, because both of her parents are aging and we're running into all kinds of snags. And I'm telling you, it's a pain in the butt, but you need to maintain a copy of it. And you need to be prepared to give it to every doctor, every hospital, every care facility. I'm living it secondhand, which is much closer than I ever want to. But the reality of it is I'm sure that I'm going to have to deal with it at some point in time. The only advantage of my dealing with it is it makes it better and easier for us to be able to explain as advisors to our clients and to the viewers the pitfalls and the things to look for.
Absolutely. Going right off the medical power of attorney, they kind of go hand in hand with one another, is the living will. Sometimes you will see them packaged together as the advanced medical directives, the medical power of attorney, and the living will. The living will basically says whether or not you wish to have pull the plug, per se. If you're in that state where you're very slim chance of recovering from, there was a very famous court case a number of years ago with Terri Schiavo, where Terri was incapacitated. Her husband said, you know what? She's probably not going to come out of this. She would want to pull the plug, per se. Her parents were on the other side of the aisle saying, you know what? We can't do that. It's our child. We don't want to pull the plug. It was a long drawn out court case, cost both sides a bunch of money. And more than that, the relationship became very rough between the husband and her parents. What you'll often find with all this estate planning is that there are layers of protection that it affords, but it really helps your family more than anything else. It helps you, it allows you to make the decisions, and it helps your family down the road that they're not having to make those difficult decisions.
Correct.
Specifically when you're dealing with someone being incapacitated or in the vegetative state or passing away, your family's already going through a lot. To not have to make those difficult decisions and that there not be infighting about it is also another layer that's just super helpful for your family.
All right, and going back to the Terri Schiavo case, she did convey to her husband prior to that, and they've had the discussions that if I am ever she was totally incapacitated and never coming back. She was in a vegetated state, but she lived that way for a few years.
Yeah.
And just think of the hospital costs of someone basically being in a vegetative state 24/7 in a hospital room. I just think of what it costs for full nursing care for someone who's like at least breathing and moving. That's $12,000 to $15,000 a month. Could you imagine a hospital room?
Yeah, I can't imagine. But you have that document in place. It helps avoid all that headache.
Correct.
The final component of an estate plan, and I said the first four that we just went through, I would say pretty much broadly apply to everyone. The fifth is going to be trusts. So trusts, depending on the situation, can be very useful tools. I wouldn't say everyone out there needs to have trusts, but it's certainly something they can consider. Trusts essentially are a wrapper in which you can move assets into that offer some layers of protection. There are some tax benefits of it. We'll dive a little bit deeper into trusts, but just know that they're out there.
And to put it into perspective, and we're going to wrap up this segment with it, there are two types of trusts. There are revocable trusts and there are irrevocable, irrevocable, for both, like irrevocable because it sounds right. But anyway, revocable trust is one with which you can change your mind. You can do it. You can do whatever you want. Irrevocable trust is once it's in there, the terms of the trust cannot be changed. They also have a term called testamentary trusts, which quite frankly are most trusts. Most trusts are testamentary, meaning that the language of the trust exists, but it doesn't come into fruition until the person passes away. Once the person passes away, bing, it springs the trust into action, and then the assets go into it. Trusts are a very, very important tool for estate planning for people who want to control the disposition of their assets long after their death. So stay tuned, and we'll pick this up after the break. We'll be back with you in just a few moments.
Do you keep up regularly with your investments? Where exactly are your hard-earned dollars going? Are you financially prepared for an emergency?
I'm Mike Menninger, founder of Menninger Associates Financial Planning. We believe that education and knowledge are powerful, and we want our clients to understand why we are making the recommendations that we make. It's your money, and you deserve to know where it's going, because it's not how much you make, it's how much you keep. So call us today to discuss your financial concerns. Welcome back to Financial Planning Explained. We left off talking about trusts, but before we go into that, because a lot of discussion on trusts are going to be addressing some of the pitfalls that people could or may or will run into. Okay, the trust gives the ability to solve the problem. But before we do that, what we want to talk about is people think, everything goes to the will.
Yep.
All right. Well, not really. In fact, I'll let you pick it up from here.
Yeah, in the first segment, I said, you know what, everyone thinks the will is the end-all be-all. And that's not necessarily the case from an asset perspective. So let's talk about what actually goes to the will. When you pass away, your estate is what's left over. All of your assets that you owned when you were living are now in your estate when you passed away. And everyone thinks, okay, your estate goes right to your will. That's not necessarily the case. There are a bunch of items and assets that come out before it even gets to the will. First, anything held by registration. So if anything is in a joint account, if Mike and I own an account together, I pass away, the assets go right to Mike. They don't even go to Mike. Mike already had access to them. So if you pass away and something's jointly owned, the other owner on the account or asset already has access to it, and they continue to have access to it. Doesn't go to the will. The next is going to be anything by beneficiary designation. A lot of times, all of your retirement accounts have to have a beneficiary designation on them. Your IRAs, Roth IRAs, 401ks, 403bs, 457s, you name it, all of your retirement accounts have a beneficiary on them. So if you were to pass away, it's going by the beneficiary listed on your retirement account, not going to the will. You also have other things that have beneficiaries. Life insurance has beneficiaries to it. If you have a pension that may have a beneficiary associated with it. All of that not going to the will, it's going to be by whatever the beneficiary designation is. There are some assets like regular investment accounts that don't have to have beneficiary designations on them, investment accounts, bank accounts, but you do have the ability to essentially add a beneficiary designation. If it's an investment account, you can add a transfer on death or TOD designation that essentially assigns a beneficiary to that account. And if it's a bank account, you can add a POD, payment on death, which essentially, once again, is assigning a beneficiary to an account that wouldn't otherwise have it. One thing I actually learned about recently is that some states allow basically a POD or a TOD to be assigned to a house. I know we kind of ran into that recently. Some states, that's very state specific. We can talk about another way that you can kind of assign a beneficiary to a real estate asset like that through the use of trusts, but some states do allow that. So when it really gets down to it, the only assets that are really going to your will are assets that are held in your name only, not everything, just assets. So if you have a bank account that's in your name only without the TOD, if you have a car that's in your name only, personal belongings that you may have, that is really what's being dictated by the will.
So the other thing that we wanted to point out is beneficiaries are revocable trusts, okay? A revocable trust will name a beneficiary, which means that you had pointed out that you can take an investment account and name a beneficiary. You could also take an investment account and name the revocable trust as the owner of the account. Now, let's say, for instance, I had an investment account and I wanted to name a beneficiary. I could do a POD or a TOD actually, if it's an investment account. I could do a TOD. However, I also have the ability to say, I am going to create a revocable trust, which again, a trust is nothing more than a document that specifies what happens while I'm alive, and then what happens when I pass away. So the trust has a beneficiary. Now, the trust does not get any special tax privileges. In fact, what happens is that the tax ID number of that revocable trust is my social security number.
Yeah, I think a great way to think about it's very much an extension of yourself. An irrevocable trust is its own entity. To your point, a revocable trust shares the same tax ID number. Mike kind of mentioned earlier, but you can put stuff in a revocable trust, take it back out, doesn't matter. Once assets go into an irrevocable trust, they're not coming back out. That irrevocable trust has its own tax ID number. It's its own entity. It's subject to its own taxes if income stays within the trust, in the irrevocable trust.
Right. So that begs the question, if I'm getting taxed exactly the same way with a revocable trust than I am with my own investment account, why in the world do I need a revocable trust? Well, I can give you a couple good reasons. Number one is the beneficiaries that I choose for the trust may be more complex than a stinking TOD will do. Okay. But more importantly, the primary reason why people use a revocable trust is to avoid probate. Now, probate, people hear, oh my goodness, it sounds like a dirty word. It's not. Okay. All probate is, and I am simplifying it, all probate is the administrative process. So the administrative process is if an individual dies, the executor grabs their will. They go down to, in our case in Pennsylvania, they go down to the county of the person who died. So, I live in Montgomery County. It doesn't matter if my executor lives out by Pittsburgh. We're dealing with Montgomery County because that's my county of domicile. So they go down to the county and they get the death certificate. Actually, the death certificate is usually provided by someone else, the short certificate. But what the job of the county is to do is to verify the validity of the will. The other thing that the county does is they post open because, hey, is there anybody who has a lien against my estate for whatever reason? So they have to post it for public notice. But what's also happening is everything I own becomes public knowledge.
Anything that's in the will then becomes public knowledge, correct?
That's correct.
Anything that comes out before anything by beneficiary designation, not going to be in the will, not going to be public knowledge. Anything that is dictated by the will is now public knowledge. Anyone can see what you have. To your point, creditors can then go after the estate. Correct. It opens it up. And we kind of talk about, okay, this is what happens if you do have a will, but what happens if you don't have a will?
Oh boy.
So if you don't have a will, you're passing away intestate, meaning you don't have a will. Now the court is dictating what happens to your assets.
Correct.
You no longer have that decision. Your family doesn't get to make that decision. Depending on the state you reside, there's different pecking order in PA. Some goes down to the children, some goes to the spouse, some can go to the siblings. Long story short, you don't want the state to be making the decision for you. You want to be making that decision.
Not to mention, you go through intestate, which is spelled the same way as interstate without the R. It's intestate. You go through intestate, trust me, the amount of time and effort and irritation and hair loss is going to be a whole lot more. So what ends up happening again is what's interesting about it is one could structure their estate that nothing goes to the will and effectively don't even have to really go to the city, right? Go to the county. Mm-hmm. Because if all of my assets are either held jointly, all of my IRAs, Roth IRAs, pensions, you name it, life insurance, annuities, revocable trusts, all go to a beneficiary. The only thing that is held in my name, or the only thing that goes to my will, is stuff held in my name only, which the house. Okay. What a lot of people will do is they'll put their house in a revocable trust. Okay. Because what happens? They pass away, goes right to whoever their beneficiaries are. Another reason you'd use a revocable trust, particularly in Pennsylvania, because a lot of people in Pennsylvania own New Jersey shore properties, is even though there's reciprocity between Pennsylvania and New Jersey, there's still a hassle administrative process to go through to get your property to go to your beneficiaries. So it is encouraged by many attorneys to take your properties that are held in a state other than your home state, put them in a revocable trust. And this way, they get distributed to where you want them to go, and you avoid probate, and you avoid the hassle administrative process.
Yeah, exactly. And to Mike's point, there are some states that are much more difficult and frustrating from a probate perspective. So if you have a property in one of those states, don't deal with it. Put it in the revocable trust. You now avoid the probate. The executor has one less thing to worry about. Your beneficiaries aren't jumping through hoops. So if you kind of know that it's a more difficult state, that's all the more reason to avoid probate through the use of a revocable trust.
Perfect. So what we're going to do is we're going to wrap up here. And so we talked kind of the fundamentals of what you need to have, how the estate process works in a very simplistic way, what goes to your will, what doesn't go to your will, et cetera, et cetera. What we're going to talk about in the next episode is a little more of estate planning. That was 101, the basics. We're going to take it and go to a little bit more of an advanced level for those folks who may have younger children, larger estates, or other tricky things, second marriages and things along that nature where it's not as straightforward. We're going to talk about that. And we're also going to get into how estates are taxed. So stay tuned. We will see you on the next episode of Financial Planning Explained. If for some reason you wish to have any questions whatsoever, you are welcome to reach out to us. We can be reached at our phone number is 610-422-3773, or you could check out our website, which is www.maaplanning, like Menninger and Associates, MAA, pretty creative.
I see what you did there.
maaplanning.com. We have tons of really cool stuff on there. So again, if you wish to reach us, you can also contact us through the website. So again, thank you for joining us, and we'll be back with you with the second episode on the estate planning. So thank you. You have a wonderful day now. Thank you for watching this episode of Financial Planning Explained. We strive to provide an educational experience for all of our viewers, and what we struggle with at times is topics. So if there's an idea or a topic that you would like for us to discuss on a future episode, please email us at admin@maaplanning.com, or you may enter it on the Contact Us page on our website at www.maaplanning.com. Thank you in advance for participating and helping make our show successful.